Morning, guys. The Constitution isn't just a bunch of words on a piece of paper. They are a written, solid contract between the people and the government. The people wrote the contract, government signed it. They are obligated to do what you tell them, not what they want to do. And the reason for this, why I'm getting into this thing here already, is they're trying to change the laws in these states to own firearms. They think they have the right. Well, they don't have the right. And I'll explain to you why. If you go back and you look at anything that has to do with militia, it says anywhere from 16 to 50 years old, able-bodied men, or some or more up-to-date ones say 17 years old up to 50 is a militia. Okay, but we're not going to use all this stuff at the moment. We'll get to this. Now, when you're 17 years old, and say that you're in school and you get a girl pregnant, and you want to get married, but you're underage. So you've got to have your parents' permission to get married. If you want to go to the military and you're 17, you're not old enough to join because you're not an adult yet. You wait till you're 18, unless you have your parents' permission. You understand this? Okay. Well, now we'll go back to the contract. The contract is the Second Amendment with a militia clause. You see where I'm going with this thing? Now, everything with the Constitution, you look in Article 6. It says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state to the contrary withstanding." The Constitution is the supreme law of the land. Madison versus Mulberry. Okay, now with the militia thing, with the kids, which aren't kids really. The ultimate right to keep and bear arms belongs to the people, not the states. As the language in the 10th Amendment shows, these two are, of course, not identical. And when the Constitution means states, it says so. Thus, the people at the core of the Second Amendment are the same people at the heart of the preamble in the First Amendment named citizens. What more, the militia is used in the amendment and in U.S. Constitution Article 1, Section 8, Clause 16, and it had a very different meaning 200 years ago in ordinary conversation today. However, nowadays it's quite common to loosely speak of the National Guard as a state militia. But 200 years ago, any band of paid semi-professional part-time volunteers like today's Guard would have been called a select corps, and viewed in many quarters as a little better than a standing army. In 1789, when used without any qualifying adjective, the militia referred to all citizens capable of bearing arms. That seeming tension between dependent and the main clause of the Second Amendment thus evaporates on closer inspection. The militia is identical to the people in the core sense described above. Indeed, the version of the amendment that initially passed in the House only systematically shortened it to the Senate version, explicitly defined the militia as composed of the body of the people. Thus, in the sense, the word militia is used in Clause 16 and throughout the Federalist paper, in keeping with the standard usage confirmed by contemporary dictionaries, legal and otherwise. The most dramatic evidence, however, comes from the 1866 Civil Rights Act, Siamese twins. The Freedmen Bureau Act, initially introduced as a single act, the two bills were later split, but were understood as in para materia as in subject matter. It finally adopted the Freeman Bureau Act, and it spoke of the benefits of the new law and all proceedings concerning personal liberty, personal security, and property, including the constitutional right to keep and bear arms. So this thing, you know, they think, well, the states have more power than the people. They do not. The states do not. Yeah. Yeah, the ultimate right to keep and bear arms belongs to the people, not the states. And the language of the 10th Amendment shows that these two are not identical. When the Constitution says state, it says so. But the people are at the core of the Second Amendment. Same as at the heart of the preamble in the First Amendment named citizens. Now this digs up a whole lot of can of worms here, because according to the 1968 law, if you had to be 21 in order to buy a handgun. Well, past practice, people, in the Constitution, before the law, anybody who was 18 years old could buy a rifle or a handgun. It predates that law that they passed and made it unconstitutional, null and void. Anything that conflicts with the Constitution is null and void. Militia means anybody 17 to 50 years old. That means the government nor the states have the right to change law to supersede the Constitution. Now all those laws from 1968, well of course the laws after 68 are getting their power from the 1968 law. The 1968 law is unconstitutional and therefore null and void, and all the other laws that followed after there is null and void. Now the National Rifle Association should be able to figure this out on their own, but maybe they need some help. I don't know if I'll ever have time to send it to them, but that's the law. You're in a militia, or if you're considered militia, from 17 years old till 50. It's always been. It's past practice. They got to honor that. You can't go running around changing laws on a whim. They're breaking the Constitution. And like I said, the Constitution is to bind the government, not to bind the people. It's to bind the government from overreach, from overstepping their bounds. And that's what they're doing here. They're after your Constitution, they're after your guns, and frankly, we're not going to let them have either one. Now guys, I want you to run that through your head, because you know what I'm saying here is the absolute truth. If you were under 17 or under 18, you had to have a parent's permission because you weren't an adult yet. But when you were 18, you could join the military or do whatever. You could go to the bank and get a loan. You could go buy 3.2% beer back then. That's what it meant to be an adult at that time. And like I said, that 1968 gun law, I mean, it may look legal and legit, and all it has is the color of law. It has no real foundation. They keep rushing into laws. Now when the Constitution was written, they took a long time to get it wrote. But our representatives and senators anymore, they rush into anything without any kind of thinking, and then the people are stuck with it. Thanks for listening, and make sure this stuff gets around.